Like, follow, and share. Like coming you heard, we dare. Pulses of the port, why do people leave? Crank up the truth with Beth and Steve.
Hey everyone, and welcome to the Deep Dive. We're taking a break from our usual Like Coming Ya Heard format to bring you something special.
That's right. We've teamed up with the Deep Dive to give you, our listeners, a crash course on something we get asked about all the time.
Yeah, you know it.
The Pennsylvania Right to Know law.
That's right. It's Steve Marshall and Beth Fulmer here, your hosts from Like Coming Ya Heard, and we're ready to unlock some serious information power today.
Now, before we get into the nitty-gritty, let's set the stage. This law isn't some dusty relic from the past. It was passed unanimously.
Unanimously?
Think about that. Everyone agreed.
Wow.
Back in 2008. That tells you, right there, it's something both sides of the aisle saw as vital.
Okay, so unanimous passing. What's the big idea that everyone got behind?
Transparency, plain and simple. This law is all about making sure citizens like you have the right to access public records. We're talking about government documents, data, pretty much anything created or maintained by a public agency.
So if it's government-related, it's fair game.
Well, with a few exceptions, which we'll dive into later. But the key here is the presumption of openness. That's the bedrock principle. Here in Pennsylvania, those records are considered public unless there's a specific and justified reason to keep them under wraps.
Whoa, hold up. So it's not like asking for a favor. It's like, we have the right to this stuff. Unless there's a really good reason to say no.
You got it. It flips the script completely from a system where you have to prove why you need access. It's the government's job to prove why you shouldn't have it.
All right, Like Coming Ya Heard listeners, picture this. You're curious about a local development project. Maybe something happening right here in Williamsport. Or a county decision that's got you scratching your head.
This law gives you the power to see the plans, the environmental impact studies, even communications between developers and officials. It's about lifting the veil, so to speak.
Okay, that's pretty powerful stuff. But let's get practical. Let's say I want to file a right-to-know request. Where do I even begin?
First things first, you need to find the right point person. Every agency, whether it's the city, the county, or a state department, is required to have a designated open records officer. They call this person the AORO for short.
So this is like my information guru within the agency.
Exactly. You can usually find their contact information on the agency's website or by giving them a call.
I got my AORO. What's next?
You need to submit a written request. You can do this in person, by mail, email, or even fax.
Really?
Yes, fax is still a thing. But here's the crucial part. Be specific. The more specific you are about the records you want, the smoother the process will be.
Got it. So no vague fishing expeditions, right?
Right. If you're looking for records about, let's say, spending on road repairs in a particular neighborhood, don't just ask for all records about road repairs. Be specific about the neighborhood, the time frame, the types of records you're interested in, like invoices or contracts.
Okay. Makes sense.
We're close.
Consent. Now what?
No.
Do I just sit back and wait?
Not exactly. The agency has 5 business days to respond to your request. They can either grant you access, deny access, or partially grant and partially deny. But here's where that presumption of openness comes into play again.
Oh, tell me more.
If they miss that 5-day deadline, it's automatically considered a denial. They can't just ignore you and hope you go away. The law puts the burden on them to act promptly.
That's a pretty tight deadline. 5 days seems fast. I wonder what's happening on their end during those 5 days.
This is where the ARO really earns their keep. They're not just a mailroom for requests. They need to know the law inside and out to figure out if any of those exceptions apply. They have to identify the relevant records, see if any parts need redacting. It's a lot of work.
It sounds like a high-pressure job. Are there any consequences if they mess up or try to hide something?
Oh, absolutely. If a court finds an agency acted in bad faith, they can be ordered to pay your attorney fees.
Ouch. That's hitting them where it hurts.
And there's also a potential civil penalty of up to $1,500 for each bad faith denial. So it's not just a slap on the wrist.
So there's real muscle behind this law.
Absolutely. The Right to Know law is a serious tool for transparency, and the penalties reflect that.
Well, Like Coming Ya Heard listeners, we've just scratched the surface here, but hopefully you're already starting to see the power this law puts in your hands. Stay tuned, because in the next part of our deep dive, we'll be exploring what happens if your request is denied and how to navigate that whole appeals process.
That's right. We'll be back.
Welcome back, Like Coming Ya Heard, folks. We're deep in the trenches of the Pennsylvania Right to Know law. Before the break, we talked about how to make a request to tight deadlines, even some penalties for agencies that don't play by the rules.
Exactly. And now we're going to talk about what happens when your request hits a roadblock, because let's be real, it doesn't always go smoothly.
Okay, so let's say I made my request, dotted my I's, crossed my Y's, but I get a big fat denied stamped across it. What's my next move?
First, don't panic. A denial isn't always the end of the story. In fact, it might just be the beginning of a more interesting chapter. Remember what we said about those specific reasons? The agency can't just say no. They have to explain themselves in writing, citing the exact legal justification for withholding the records.
So it's like a no BUT situation. They have to give me a reason that holds water.
Exactly. And this is where things can get fascinating. Those reasons often point you towards the next step, the appeals process.
Appeals. So it's like going to a higher court.
You got it. If you disagree with the agency's denial, you have the right to appeal to the Pennsylvania Office of Open Records, or OOR for short. They're like the referees of the right to know world.
Okay, I'm picturing a bunch of folks in striped shirts reviewing my request. But seriously, how does this appeal thing work?
It's pretty straightforward. You have 15 business days from the denial to file your appeal with the OR. They assign an appeals officer who dives into the details of your request, the agency's reasoning, the whole 9 yards.
And this officer, are they like a judge? Do they have the final say?
They're more like a neutral investigator, making sure everyone played fair. The appeals officer will issue a determination within 30 days, either upholding the denial or ordering the agency to release the records.
So most cases get settled right there with the OR.
A lot of them do, but if either you or the agency still aren't happy, you can take the matter to court for judicial review. It's like the Supreme Court of right to know cases.
Okay, that's pretty intense.
Yeah.
But honestly, knowing there's that whole appeals process that someone else can double-check things, that's reassuring.
It's definitely designed to make sure everything's on the up and up. Now let's shift gears a bit and talk about something that often comes up in these requests and denials. Redactions.
Redactions. Is that like when they black out parts of a document? Kind of like a censored document you'd see in a spy movie?
You got it. Sometimes even if you win your appeal and get access to a record, you might find some parts blacked out. This is where those exceptions we talked about earlier come into play.
Okay, I'm starting to see the connection. So even if the whole record isn't off limits, some parts might be protected.
Exactly. It's all about finding that balance between transparency and protecting certain sensitive information. For example, they might redact personal information like social security numbers or home addresses to protect someone's privacy.
That makes sense.
Mm-hmm.
Or what about something like, I don't know, ongoing investigations?
Perfect example. Imagine you request records about a crime investigation. They might redact parts that could jeopardize the case, like the identity of witnesses or confidential investigative techniques.
So it's not always some big conspiracy to hide things. Sometimes it's actually to protect people or ensure a fair process.
Right, redactions can be legitimate, but it's important to be aware of them and understand why they're being used. If you think an agency is overusing redactions or hiding something they shouldn't be, you can always challenge it through the appeals process.
So there's always that check and balance. I like that. Makes me feel like I'm not powerless.
That's the whole point of the law, to empower citizens like you to give you a voice and a way to hold the government accountable.
All right. Like Me, I Heard listeners, we've covered a lot of ground. We've talked about denials, appeals, redactions. It can feel like a maze. But stick with us, because in the final part of our deep dive, we'll be looking at real-life examples of how this law has made a difference right here in Pennsylvania.
We'll show you how everyday people use the right to know law to get answers, expose wrongdoing, and make their communities better. It's going to be inspiring.
Welcome back, Like Me, I Heard listeners. We're wrapping up our deep dive into the Pennsylvania right to know law. We've covered the nuts and bolts, making requests, handling denials, even those sneaky redactions.
And now it's time for the good stuff. We're going to explore real-world examples of how this law has been used to make a difference right here in Pennsylvania. Stories about everyday people who took on the system and won.
Okay, I'm ready for some inspiration. Hit me with your best shot.
All right, let's start with a case that hit close to home for many of us, public school finances. A few years back, there were some folks in a nearby county who were concerned about how their school district was spending taxpayer money.
A common concern for sure. Schools always seem to be asking for more money, but it's not always clear how it's being used.
Exactly. So these folks decided to use the right to know law to get some answers. They requested copies of the district's budget contracts with vendors, even the salaries of administrators.
Whoa, hold up. You're telling me they could actually see how much the superintendent was making?
That's right. You might be surprised by the level of detail you can access with this law, and in this case, it really paid off.
What did they find?
Well, let's just say their suspicions were confirmed. They uncovered some questionable spending practices, like lavish travel expenses for school board members and contracts awarded without competitive bidding.
Sounds like a classic case of the good old boys network. What happened next?
Armed with this hard evidence, these folks went to the media, they presented their findings at school board meetings, they raised a ruckus.
I bet that got some attention.
It sure did. The public pressure became so intense that the district was forced to conduct a full audit and make some major changes to their spending practices.
And talk about citizen power.
That's the beauty of the right to know law. It gives you the tools to hold your government accountable, even when they'd rather keep things hidden.
Okay, that's one powerful example. Got any more?
How about a case involving environmental protection? A few years back, there was a company here in Pennsylvania that was suspected of polluting a local river.
Sadly, we've seen those kinds of stories before. Companies trying to cut corners and pollute our waterways.
It's a shame, but thankfully we have tools like the right to know law to fight back. In this case, a group of concerned citizens requested records from the Department of Environmental Protection. They wanted to see the company's permits, inspection reports, any evidence of violations.
And I'm guessing they found something.
You bet they did. The records revealed a history of violations and a pattern of the company ignoring environmental regulations.
So what did they do with this information?
They took it to the media, contacted their elected officials, and even filed a lawsuit against the company. The pressure worked. The company was forced to clean up its act and pay hefty fines for the damage it caused.
Another victory for the right to know law.
It's a powerful reminder that we don't have to sit back and let polluters ruin our environment. We have the right to know what's happening and to hold them accountable.
These stories are incredibly inspiring. I bet our Like Coming Ya Heard listeners are starting to see how they can use this law in their own lives.
Absolutely. Whether you're concerned about school spending, environmental issues, or any other aspect of local government, the right to know law can help you get answers and make a difference.
It's about taking ownership of your community right, making sure things are done right, and holding those in power accountable.
Exactly. Transparency is the foundation of a healthy democracy, and the right to know law is one of our most powerful tools for achieving that.
Well, Like Coming Ya Heard listeners, this has been an incredible deep dive. We've learned about the ins and outs of the law, explored real-life examples, and hopefully you're feeling empowered to use this tool yourselves.
Don't be afraid to ask questions, to seek information, and to hold your government accountable. Remember, knowledge is power, and the right to know law gives you that power.
Thanks for joining us on this special episode of The Deep Dive. And as always, stay informed, stay engaged, and keep on listening to Like Coming Ya Heard.